Talking Law with Eugenia, and I'm with my special guest Henry James of Henry James Legal, 0414 414 520. If people want to send questions while we're on air, text me 0401 269 091. That's 0401 269 091. Now, the first topic is lending money to family and friends, the tips and the traps. I'm going to start off by saying this to you, and then Henry will be leading this discussion because it's his area of law. If a bank who is an expert at assessing financial risk won't lend money to someone, that should be red flag to a bull about what you need to think about. I personally wouldn't do it. I think it's fraught with danger, but if you insist on lending money to a friend or a family member, then you need to do it properly so that each of you knows what your rights and responsibilities are. And I'm now going to hand you over to Henry James of Henry James Legal, 0414 414 520, to continue the discussion. But remember, this show is brought to you by Adelaide Hills Toyota. Henry, welcome.
Hi, Eugenia. It's a really good topic, and it's something that I'm finding I'm getting a lot of inquiries in recently. I'll start off by saying that I really empathise with anyone who wants to help out a family member. I certainly understand the knee-jerk desire to immediately step in and try and save a family member in financial distress. I don't think anyone can criticise someone for wanting to do the right thing, but the problems all arise from the fact that fundamentally, when you're dealing with family, you tend not to be nearly as commercial as you would be if you were lending money to just some random off the street. And that lack of commerciality, that lack of coming to it with a commercial attitude is often what I find in practice the starting point of all the drama. So the first thing that comes to mind on that is, by not being commercial, everything's verbal. Everything's in, he said, she said, phone calls, text messages. Nothing's really formally written down in writing.
And sometimes it's not even in a text message. It's just a conversation.
Absolutely. And what's worse than that is that even if you were to take everything that was said verbally, even if you were able to prove in court everything that you said and that they said, the discussion, whether it's verbal or written down, often isn't a commercially sort of based discussion. So a lot of the really important issues are not even discussed, even verbally, between family members. And among those issues, the thing that I find that they often lack is really a laying down of the expectations at the beginning.
Exactly.
Saying, this is a gift, or no, it's not a gift, it is a loan. Pay me back when you can pay me, or versus, no, I want to be paid back every fortnight and I want you to pay me X dollars each fortnight, whether you're expecting to be paid back with interest, without interest, very, very difficult. And some of the basic parameters of the loan, as it were, are often not contemplated by the parties until it's far too late. And the problem you've got then is you can't really backtrack. It's really hard to then say, oh, actually, son, I've changed my mind. I'm now readjusting the terms of our agreement. That just gets messy. And then you've got the situations, of course, where you've got verbal agreements where people have already loaned the money and then they say, well, actually, we'd better put this in writing. Well, I think we might touch on that a bit later on. I think I did see we got a question about that a bit later on, Eugenia. But really, I take heed from a saying that Dave Ramsey, who's an American expert on money and all things financial, that he says on his podcast, which is, if you take money from your family, it has a way of making Christmas dinner taste funny.
Oh, absolutely.
And what he means by that is that if you take a loan from your parents, or even worse, your in-laws, you can best believe that if you turn up to Christmas dinner in a brand new car, or if you're about to take the families on a holiday to Corfu, or your wife turns up in an expensive new dress that she's bought, you can best believe that there will be very, very scornful and critical looks thrown your way throughout the dinner. Every single financial decision you make will be so strongly criticised by your family if they've lent you money.
Exactly.
Because the first thing they're going to say is, how badly did you need that 50 grand to get you out of that tricky spot if you can afford to fly the kids business class to Seattle this Christmas for a holiday?
Exactly. My father used to say, and I remember this often because he would often do handshake deals with family members, but he always took the view, if you're going to lend money, then you better be prepared to lose it.
Yeah.
If they pay you back, it's fantastic. You can loan money again, but you certainly wouldn't start by giving someone $100,000. I had a phone call this week from someone that lent someone a few $100,000 and the family member isn't paying back. Now, this isn't my area of law, it's Henry's. So I referred the client on to Henry, and it's a really, really sad situation, but it's not uncommon. They now need the money, they're not getting the money, and it's caused all sorts of financial strife for him. So really, if you're going to lend money, it's one thing lending someone $50 to get some groceries or some petrol in the car. It's another thing to lend thousands of dollars.
And you'll often find that when family do come begging for money, it comes with little to no warning.
Exactly.
So it's, son or dad or, uncle, auntie, I need to borrow money today. Like, the sheriff's at my door, or, the bank's about to repossess my house, or, should I owe someone money and I need it now.
We talked about that on the way, didn't we?
Yeah, absolutely.
About the sheriff's coming.
You know, whether they are intending to or not, it puts the person lending the money under enormous pressure.
Exactly, it sure does. And remember, if your story is, they're now taking me to court, or we've been to court and the sheriffs are at my door, what does that actually really mean,
Look,
Henry?
it means that they've gone through, normally they've gone through some sort of litigious process where the court's heard out their side of things, the person that is owed money's side of things, and the courts ultimately come to a determination that your family member is in the wrong and they do owe the money. But if the sheriff's getting to the door, that means not only have you gone through the litigious process, but you've also probably gone through the debt recovery process as well, which is where the court's then gone, well, we've told you to pay this person, you haven't paid them, now we're going to examine what you've got. And they've gone, you've got a house that's got some value, well, we're going to order the sheriff to sell your house. So at this point, the family member has kept quiet about their problem for probably far too long at this stage, and now they're clutching at straws at the 11th hour, expecting their hard-working relatives that have got a little bit of money put aside are going to just swan in and rescue them. Now, that's the two things that I have to say about that is, firstly, the person that's been approached should always keep heed of the phrase, you can't fill a glass from an empty jug, meaning that unless you yourself are financially very well off, and as Jenny suggested, are in a position financially that if it all went pear-shaped, they could afford to write the money off, I'd say you really, really think hard about whether you want to put yourself in that position. But the second thing I'd say is if a person's coming to you at the 11th hour expecting to be bailed out, what assurances do you have at all that this is going to be the one and only time that it happens?
Exactly. And I can tell you, if the sheriffs are at your door, you've been in court for about 12 months at least. The court's heard both sides of the story, as Henry has said, and they've decided, no, you owe the money, you're not making an effort to pay back. I'm allowing your creditor to come to your house and seize cars, furniture, antiques, whatever it is you've got that can be sold to repay the debt. And that's not a good thing. That should tell you, if your family member rings you or your friend rings you in that situation, they can't pay it. They either don't have the money in the first place to pay, or they're just not paying. Either way, it's a red flag to you to say, I'm not lending them money. They might be crying on the phone, but this is something of their own making, and unless you are very, very wealthy and you can afford to lose 10,000, 50, 100, couple of 100,000, and not many of us are, I couldn't do that.
And look,
don't give it.
If 8 years in practice has taught me anything, Jenny, it's that some people are real Olympic level experts at crying on the phone.
Exactly, they sure are. I've seen that a lot. Anyway, and then you end up bringing a lawyer, and there's that expense as well. And you may not even be able to afford your lawyer now because you've given your money away. And let's be really blunt here. This is my view. Henry will give you the legal stuff, but from a human point of view, I've given away money. Stupid me, do I feel like a goose at the moment? But not only is this person taking the mickey out of me, I can't even afford to pay a lawyer because I've given him my money. I might have bought a house and I've got settlement coming. Now the vendor that I bought the house from is going to sue me because I'm not settling on the property. I've got you bozo, who won't give me my money back. I've seen marriages end on this type of thing. Family relationships destroyed, friendships destroyed. You know, you don't want to be in that position.
People dig themselves into a hole, Jenny, and a lot of the time they've been digging for so long before they call the lawyer that it's just one big old mess for you and I to sort out. And that sometimes if you can see the signs that things are going pear-shaped, get some advice at that stage.
Okay, now, I think we've done the question. I've lent money based on a conversation. Now I can't get my money back. What can I do? You need to see your lawyer immediately. Question 2, I've already lent money. Can we still make a formal agreement?
Well, look, the short answer to that is yes, but the more practical answer is it's going to be difficult. And what I mean by that is you've kind of played your hand at that stage because they've got your money. So really, where's the incentive for them to then bind themselves to a written contract when they've already got your money in their account?
And I believe that type of contract where it's made after the fact has a special term. Is it a deed of a deed?
It could be done by way of a deed of agreement that sort of formalises what's already been agreed to previously. But to a certain degree, encouraging another party to enter into those types of arrangements really relies on them agreeing to do the right thing.
And what
because if it's verbal at the end of the day, what's to stop a person from saying, oh no, that was a gift?
And what if you want me to have a contract with you after you've already lent me the money and I say, but that's not what we agreed to?
Well, exactly, and this is the problem. And it comes back to what I started off with is what I see to be the fundamental underlying problem with lending money to family and friends is that you are not approaching it from a commercial point of view. And part of that is that you don't go into it thinking, we better have a written agreement.
Okay. Now, we're going to go to a song because it's time, but when we come back, Henry, I've got a question that was sent. It's, can I go to police about the family or friend who refuses to repay me my loan? Is there a criminal component? We'll come back after we've heard the song Something Happened on the Way to Heaven by Phil Collins. Talking Law with Eugenia. I'm your host, Eugenia Matthews. The program is brought to you by Adelaide Hills Toyota. And also, I can tell you that Henry James is still with me. I know he's got a fan club and I don't, but you know, somebody must love me. 0414 414 520 is Henry's number should you want to get in touch with him. Now, before we went to the break, the question was, can I go to police about the family or friend who refuses to repay me the loan? Now, that brings in some criminal elements, or they may not be criminal elements. Henry, what do we say to that question?
What we say about that is, generally speaking, money owed between people is a strictly civil matter. And if you go to the police, they'll typically say, oh, sorry, sir or madam, that's a civil case, we're not getting involved. However, if there is an element of fraud involved, that may well be a criminal matter. So,
absolutely.
Where, for example, we've used the example previously of, the sheriff's at my door, please, 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 I need the money. If that all turns out to be a complete lie and a fabrication, then absolutely that could be considered fraud. Or if someone's made clear misrepresentations deliberately to trick you into thinking that they need money and you've tried to help them out, that can absolutely be a criminal matter potentially. However, it will require that you have good grounds for claiming that, because police are going to want to see some pretty decent evidence, because they do get inquiries from people all the time wanting to get the police involved in things that really don't concern police. So if it is serious enough to involve police involvement, and by that I mean if there is an element of clear fraud, then try and put together your story as clearly as you can to show police that it is a situation that should be taken seriously. The other type of criminal element that I think could stem from this, that quite sadly I'm observing is happening more and more in our community, is instances of elder abuse. And by that I mean where some young buck in the family has gone to one of the older, probably senile members of the family, and you see this a lot in wealthy families where, great-grandfather or grandfather has worked hard all his life, has put away decent savings, but has, for whatever reason, lost his marbles, or is on his way very much to completely losing his marbles. Grandson turns up and says, "Hey, Granddad, could you lend me, $1.5 million, or could you lend me, 300 grand, or whatever it is?" And poor old Granddad, who's not completely with it, doesn't understand what he's signing, or doesn't understand what he's agreeing to, or is otherwise manipulated into handing money over to another relative who in their heart of hearts knows they're never going to pay it back, and really know that they're ripping off and taking advantage of an elderly relative. That's absolutely a matter that should catch the attention of police, and I think would be a very good example of a criminal element to a debt issue. Jenny, what are your views on that?
I agree with you. You need to always think, these are my elderly parents. If I was old, would I want some young buck in the family coming and taking my money? If you're a very wealthy person, it might not affect you very much, but most elderly people, they only have their home, and they might be getting rent for it, or they might just be on a pension and just have some savings. You can't take their money.
No.
It will be deemed as them giving it away, and that's if they're not in a nursing home yet, and they'll lose their pension. There are a whole lot of financial repercussions for the elderly person, and if they're in a nursing home, I'm sorry, but you've actually committed elder abuse.
Absolutely.
And, you've acquired that money, I think, by undue duress on the person and causing them mental anguish if they don't give you money.
And anyone who tries to justify that type of behaviour by saying, "Oh, well, Granddad was rich," is kidding themselves. It doesn't matter in the eyes of the law, and also in the eyes of common decency. It doesn't matter if a person's got plenty of money or no money. Ripping someone off, particularly a family member, is wrong. It doesn't matter if they've got $10 million to their name or $10 to their name. Ripping off your own relatives is just the lowest of the low.
Oh, absolutely. And we've got lending money. If we're going to talk about lending money, can we stretch the envelope a little bit? Because I did receive a question while we were off air. Power of attorney. And they want to give themselves a loan from the elder family members, or sometimes they've got power of attorney for their friend.
Jenny, we could make a whole show about this one topic. I've had that many inquiries from people that do not understand what power of attorney means. It is a fiduciary relationship, which means, and that's a fancy legal term, but what it means is you are not just handed the keys to the kingdom. Being a power of attorney means you have been given the responsibility by someone who, when they were with it, trusted you implicitly to put yourself in their shoes and do things that are in their best interests. It is not a license to carte blanche, line your pockets and fill your boots. It is the responsibility to do exactly what that person would have done if they were with it. And they have trusted you with that responsibility, and you should take that responsibility with the heavy burden that it carries.
And I don't think it changes just because they pay the money back. It's still a theft or an abuse of their power of attorney.
In your criminal practice, Eugenia, how many times have you seen fraudsters try and claim in mitigation that they paid all the money back, therefore it's okay?
It's not okay. The law won't see it that way.
Absolutely not.
But, it does happen. So what I've said to people in choosing their powers of attorney is don't have one person do the power of attorney. Have two people and two separate people. Don't make it a husband and a wife because if they get into trouble financially, it will be tempting to just take from the pool and I'll pay it back later. What if they've got a gambling problem? That never happens.
That comes down to a more fundamental issue, Jenny, which is you want to be picking someone who's financially astute.
Exactly. Or if they don't know, or then they've never been involved in the legal game in any way, go and get the information that you need. Now, on a show I did with Miles, you weren't present with us for that one, I said, and make sure when you do the power of attorney that they must produce the book of accounts at the end of each financial year to everybody in the family so that they know they should be proud to produce
Absolutely.
that book.
If you are to loan money as a power of attorney, and I mean if, record keeping is absolutely paramount, because in any power of attorney situation, you have to assume that the whole world is going to put you under the microscope and criticise every single move you made. So you have to be beyond reproach and have a clearly documented record of everything, every single last cent you've moved of that person's money around. You need to have a very, very clear, implicitly documented, squeaky clean record of everything you've done, because you can best believe if and when it gets litigious, you will be put under the microscope by the court.
And if you've taken money, you've loaned yourself money, whether it's to buy a car, go on a holiday, buy a house, renovate, buy a new dress, or pay for your child's orthodontic treatment, whatever it is, that is an abuse of your fiduciary duty as power of attorney. It is unlikely that an elderly person is going to say, hey, I think that's a good idea. And the other thing too is you shouldn't be wanting to do that. If you're an adult, I mean, seriously, stand on your own 2 feet. You shouldn't be going to elderly parents.
No, I've never understood people that waste their whole lives waiting for mum and dad to pop their clogs before their own life kicks off. It just seems like a waste of a lifetime.
I agree. And that led to another question that came through. They've paid the money back that they gave themselves as power of attorney. The family member or the family friend by this stage has dementia or Alzheimer's or some other cognitive disorder, and they can't make these decisions. But the money that was taken from that interest-bearing bank account, they've lost the interest. Now, is that not a theft?
Potentially. I mean, it's certainly a lost opportunity.
I would be, if it was me, my advice would be we need to go to police and say that they took the money unlawfully, because it is an unlawful act. And if they've not paid it back at the commercial rate, then that is money that you've effectively taken from them. They've lost that money because of your behaviour. The bottom line here is if you're lending money to family and friends, whether they ring you on the telephone with the sheriff at the door or bankruptcy notices because you owe enough money and your creditor has made an application in the bankruptcy court to bankrupt you, think twice. They should not have let it get to that stage. We're talking about 12 months down the track, and that is a red flag to a bull. If that happened to me, I would be thinking to myself, the sheriff's at your door or they're filing bankruptcy proceedings. You either refuse to pay them back or you haven't got the money. You're not a good bet for me. You're not a good investment. I'm not likely to get my money back from you.
The sort of whistle-stop version of what you should do if you do choose to lend money to your family members is firstly lay out the expectations very clearly about what you expect out of the relationship.
Before you give the money.
Make it very clear. Is it a gift or is it a loan? If it's a loan, how quickly do you expect to be paid back, and on what are the terms of repayment?
Will it be interest-free or will it be with interest?
Absolutely. Do you intend to take any security over something, i.e. that you're going to take possession of something that belongs to them until they pay you back, so that if it does all go belly up, at least you've got something to recover your loss?
I would be asking, and maybe it's the lawyer in me, but even before, I'm proud to say, thanks to my father who taught me this, first I would be saying no. Then I would be... let's say the sheriffs were at the door, my answer would be no at that point. But if it was bankruptcy proceedings, well, then you know that you're going to have a date in court in maybe 3-4 weeks down the track. That would be the time where I would be saying to this family member or friend, okay, come up to my house, we'll have dinner and we'll discuss your financial situation. And I would want them to be transparent with me.
And once you've had that discussion, and this is not me touting for business, I would say go to a lawyer and get it drafted up as a proper agreement.
Whether you come to me or Henry, or whether you go to TGB or Miles Harper, who also does this, or Mead Robson Steele in the Hills, or Peter Fisher, wherever you go.
Like we always say, go to whoever you're comfortable with.
Exactly. You need the bankruptcy proceedings that have been filed. At least you've got time on your hands to consider it properly. Go to a lawyer, get this done properly. Yeah. Ring the Legal Services Commission. They might be able to give you some free legal advice. I doubt it. They don't usually that issue.
If you are lending money to a family member, keep in mind that you do have the benefit of what's called the Personal Properties Securities Register. You can take out liens on items of personal property if you do want to lend money to a family member. So, for example, say that you've got the sheriff's situation, Dad, I need $250,000 immediately. And then the dad can say, well, that nice new BMW of yours, I'm going to put a caveat, effectively the equivalent of a caveat over that piece of personal property.
That means you're registering an interest in that property.
You absolutely can register an interest over that piece of property, so that Sonny Boy can't go and sell that car without paying you back first. So it's a way of making sure you've got a fallback position to at least get some of your money back.
And, you know, even if you haven't done law, dear listeners, think in terms of you're going to the bank to borrow some money. What is the bank going to put you through? What hoops are they going to put you through before they decide that they're going to lend you some money? If you're buying a car from a car yard like Adelaide Hills Toyota, who I say are very reputable, I know that hardly anyone believes me, but I did buy my car sight unseen. Thank you, Tom. It's still running well. I trusted them, and my trust has not been misplaced, but their finance people are going to put me through some hoops. They're going to know what my income is, what my expenses are, what I own, what I owe, before they decide I'm a good bet to lend money to. And even then, I'm not going to have ownership of my car until I pay them off.
Absolutely. If family are coming panhandling for money, it's probably because someone with far more commercial astuteness has done their number crunching, and they've fallen foul of their due diligence processes. As Jenny says, if the bank has turned them down, what confidence should you have that you're going to get paid back?
And remember, they are experts at managing financial risk. A bank isn't even going to let you overdraw your account by $50. It'll just be dishonoured unless you're a good financial risk.
I think the biggest pitfall that I've seen families get into recently, and it happens with, I think, the cost of living and the cost of houses at the moment, particularly with young people trying to get into their first property.
It's really sad. It's terrible.
Terribly sad. But what's even sadder is that there seems to be almost a commonplace attitude among people that it's normal for mum and dad to put up the family home as guarantor on the kids' mortgage.
You must have ESP. It's a question. Keep going.
It's something that so commonly happens these days, to the point where I think I've heard real estate agents that open inspections say, how much money have mum and dad got?
And I think that's really bad. If a real estate agent is saying that, I think you should be very careful, because what they're saying is they've made an assumption about what you're wearing and how much money you've got, but they're basically saying to you, go to your elderly parents, because you're an adult at this stage, so you're middle-aged to elderly parents, and see if you can get them to stump up for your loan. I think it's terrible.
And what some people that are perhaps not commercially weathered, as we might say,
Yep.
or have had much to do with lawyers or litigious processes, going as guarantor on someone's loan can seem like you're just putting your name down on a form.
Oh, it's not
It is
that.
not.
Tell them, Henry.
It is quite literally the financial equivalent of putting your neck on the line, or basically taking your whole life savings and putting it on black on the roulette wheel.
And I'm going to be even more blunt than the gambling roulette wheel. I'm going guarantor for Henry. Henry has decided that he can't pay, or for whatever reason he's not meeting his repayments. The bank or the financial institution comes to me and says, guess what, Jen? Henry hasn't paid. We want you to pay. It's not me just putting my name down to give the bank comfort. I'm liable if Henry doesn't pay. That's what you're actually doing.
And no amount of sob stories or tears or begging or bended knees is going to dissuade the bank from foreclosing on your home. They are a bank. They are commercially minded, probably more so than any other institution in our society. They will not flinch or blink at the prospect of putting your home on the market and throwing you onto the street.
That's right. And you also, as the guarantor, could end up on the street. We're going to go to a song, and when we come back, I'm going to, with Henry, give you a refresher on staying safe on our roads this long weekend. Okay, the song is Alone by the Bee Gees, and yes, I do like them too. Talking Law with Eugenia, the program is brought to you by Adelaide Hills Toyota, and my special guest is Henry James. Welcome again.
Oh, it's terrific to be on, Jenny.
I know, isn't it? We're now going to start our traffic refresher thing, part of the discussion, because it's the Labor Day long weekend and people are travelling from A to B and possibly interstate. A question that I have had in the past is, if we're speeding or whatever, do we get double demerit points in South Australia?
No.
However,
be very clear about that, listeners. There are no double demerit points in South Australia.
However,
if you cross the border, yes, you will have double demerits imposed, because what will happen is the roads authority that is in charge of demerit points in each state and territory will effectively send a message through to South Australia to say, we want you to mutually recognise the demerit points that we were going to impose here in Victoria or New South Wales or wherever it is. And 9 times out of 10, the demerit points that are requested to be imposed interstate will be imposed in South Australia. So effectively, if you're speeding on your way to Melbourne and you get done in South Australia, you might get done for 3 points, but if you get done in, you get just over border town, you get into nil, cop gets you over there, then it's 6 points, and you may well cop that double demerit.
And think about it, people. What time of the year are we? We're, well, it's the last day of September, so let's say October. And December's coming up. We all know the man in the big red suit, the big fat man in the big red suit. I love Santa. I've been good this year, Santa. I want a Merc or another Toyota or something. He's going to come and visit, and you might not be driving. You're going to have a really difficult time at Christmas.
Well, that's really important point, Jenny, because firstly, who of us can afford the fines this close to Christmas?
God.
Who of us can afford the disqualification this close to Christmas?
Nobody.
But what flows from that? Who of us can afford to lose our job this close to Christmas?
Or ever. Now, a question that's been asked, and this will be the final bit, and then I'll give you a wrap-up, is can I avoid a conviction if I've been caught drink driving or drug driving or speeding? Can I avoid a conviction for a regulatory offence?
All right. I would. The general answer is regulatory offending are the offences that will almost always attract a conviction. So speeding, almost always get a conviction.
Yep.
Drink driving, absolutely almost always get a conviction. Drug driving, the same. Now,
and using your mobile phone.
And using a mobile phone. All of those driving offences almost always attract a conviction, which is why I say to people, if you are given a fine in the mail and paying that fine will not cause you to lose your licence, do not risk contesting it in court, because the court finds that you're guilty, you'll get a criminal conviction recorded.
Exactly. Now, you might think having a criminal conviction for something like that isn't a big deal, and most of us think it isn't a big deal. I know farm hiring, I don't really care if you've lost a demerit point once, but if I see a record of repeated, then I'm thinking you're someone that doesn't actually conform to society's expectations.
The view I've always taken, Eugenia, is that these days work is hard to come by, and most jobs will have hundreds of applicants, and if you're looking at 3 applicants on your desk, they've all gone to the same uni, they've all got the same degree, they've all got the same amount of work experience, but one of them's got, say, a drink driving conviction or a couple of drink driving convictions or whatever. Your view's going to be, well, why am I hiring that person when they all cost the same and I can get someone else who's just as qualified who doesn't have that record?
And I can tell you, and I've done a few of these cases, if you end up in an accident and you killed somebody, you could be done under Section 19, I think it's Section 19 of the Criminal Law Consolidation Act, death by dangerous driving. The starting point is jail. You will lose your licence for 10 years. In fact, you're probably going to lose your licence before you've even been convicted for that period of time. Don't do it. Speeding, inattention to the road, keep your hands on the wheels, don't answer your phone, don't look down and answer your phone. Your eyes have to be on the road, you've got to be alert, and for God's sake, don't have any alcohol in your system or drugs. If
despite these warnings you do end up charged and you're going to court and you're worried about a criminal conviction, by all means reach out to either Eugenia or myself. I have managed to get no conviction recorded for drink driving and drug driving in exceptional circumstances. And I emphasise very much exceptional circumstances. But as always, if you are in trouble, come and see a lawyer, but try not to get in trouble in the first place.
Exactly. We don't want to see you, believe it or not. I'm sure you can find better things to spend your grudge money on instead of paying for a lawyer. It just means you've got to be sensible on the road. Don't speed, don't drink drive, don't drug drive, and pay attention. The other thing I want to tell you is I really do appreciate the text messages and the suggestions for topics that you send me, and I always choose our